So in most litigation, civil or family, there's that settlement stage, right? Like the settlement conference or the pretrial conference. And so usually in these conferences, they have this judge that presides that is different from the trial judge. And there's a reason for that. And so the reason is so that it would encourage the parties to disclose confidential information so that they can reach an agreement easier, that kind of thing. So now when I'm thinking about the Med-Arb, I'm just a little bit confused because it seems like you're saying that the mediator puts on the arbitrator hat at the end, right? If there are issues that are still not resolved, wouldn't that kind of put off some people saying, oh, this mediator, I don't want him to, or her, I don't want him or her to turn on me later. Like if I'm, disclosing this information and they've heard it, right? Like, I mean, obviously during mediation, you can't unhear something. Does that bother people? How do we? Yeah, I mean, what happens then? Like, are there ways to do the Med-Arb process so that this principle is still somehow sort of preserved?
Well, I know I've come out of a lot of case conferences and a lot of settlement conferences. And I've turned to my client in the hallway and said, "Thank God that person's not going to be the trial judge."
Yeah.
So, I think the answer is finality. I know there are issues. I know that it's there. I know that there are two schools of thought on this, and people agree. A lot of people will do mediation with one person, and then totally separate, they'll hand it over for arbitration to another person. They do that a lot with parental coordination, if an arbitrator decision is being made. I don't know if people want it. They just, you know what? Most people who come and they really get into mediation, arbitration, and they're at the arbitration stage, they just want this thing over. They want finality. They're so fed up. They're so burnt out. They're so broke. They've already gone through it. I mean, how many people have over the years who have spent $20,000, $30,000, $40,000, on the legal system, on lawyers and whatnot? They're just at that place. But I think there's thoughts both ways. I don't know. You're right about that, but a lot of judges will make orders on case conferences and settlement conferences. And I don't want to name any judges, but there are lots of judges who will force you into the settlement because they know, and rightly so, they know that we're going to waste the court's time and go into a trial and see the same decision.
Yeah.
Very blatant,
Yes.
What do you think? What do you think, Laura?
Well, I mean, I'm in not any of the school of thought there, because I do see, depending on the issue, the advantages of Med-Arb. I also do struggle, and I see families or clients and parties struggle with the idea of having the same person mediating and then arbitrating, the switching hats. So I was always somehow inclined towards the other model that you had described, Marty, where it's a sort of like a co-mediation model, really, where one of the mediators will do the mediation piece and the other one will do the arbitration piece. But in the same time, when we deal with families whom we see in the Med-Arb, there's also an advantage of knowing who is going to make the decision and kind of going through the mediation with that mediator arbitrator and sort of sensing, because we're all human, we all sense there's comments, there's all sorts of underlying sort of messages. They're sensing which way it may go. So, or what type of format the decision may look like. So that may also be an incentive to resolve the issue, right? And lots of families whom we work with gained a lot of respect. So, we were in a Med-Arb a couple of weeks ago, and Marty had shared, so we would be doing sort of the Med-Arb, and he would be doing the Arb at the end if he moved to Arb. But that family had connected so well with Marty, and they each individually gained so much trust and respect that in the end they did not proceed to ARB, because there was a conversation and there was a feel of trust that no matter what, we do trust him to make a decision, but we also trust him now to tell us, just don't waste your money into the next chapter. Let's just try and resolve it here and create something. So there was that is important to factor in. It's who and how the approach is, right? So Marty is not necessarily directive in the way that he approaches the Med-Arb, but there's a lot of humanity that came through in the in the conversations, so which ultimately had the family resolve it in the mediation phase. So there's power to that. There's power to still having the same person. That's why it depends on the issues. It depends on the people. But I think it's important for people to know that they can perhaps request that. They can perhaps, request to have to, if they, if that's the process in the end, right, that they're entering into. So they can question and they request to perhaps have two mediators, one doing the mediation, one doing the arbitration piece.
Okay, so now I really have one final burning question, which is coming from what you just said. So I like the one person model, because I think a lot of people go, well, we only have to pay the one person, right? You're right. Which actually I wonder, like when the parties have gone through the mediation with this one person, likely the mediator will know a lot about the case already, right? Having gone through the mediation. So does that mean, Marty, does that mean that you don't even really need an arbitration hearing per se? Because like the way I originally thought about Med-Arb was you got mediation, and if there are things that still have to resolve, you go to arbitration. And you were saying, Marty, that arbitration is kind of like a trial. But is it possible to have Med-Arb with one person, like with one adjudicator, so
Right.
that this person sits through the mediation, and if there are issues to be resolved, there's no hearing as such, that the arbitrator just kind of goes to his office and figures out a binding award? Can you do
Well,
that?
the parties can agree to that.
Okay.
So Laura and I did a case just recently, and we called it a parental mediator, the person, because we didn't want to, but she was almost doing like a mini custody and access assessment. But because she was appointed during the mediation stage, because that's a Med-Arb, that case, I think.
Yeah.
Yes. But we said in the agreement that she'll gather all this information and she'll make recommendations on it, but that will be admissible at the final hearing, if there's a hearing, and she'll be subject to cross-examination, the parental coordinator. So I guess the question is, if the parties want it, it could be done. I think it's probably safer, in the long run, to not so much start afresh, but to have directive questions based on whatever information is given. Like I just got as we were speaking here, stuff for tomorrow. I'd have to read it. Like it's tons of cases and all kinds of stuff. I think, oh my gosh, here we go. I love the Meds, but I hate the Arbs. And so to answer your question, yes, you can do that if the parties want to. But at some point you have to call it an arbitration. I think people have to agree, and if they agree, then the judge is not going to overturn that. As long as they had a lawyer and they had independent legal advice on it, and they said, look, we decided that we wanted this to be, the evidence been produced, and maybe we'll produce something else and make a statement or something, and that'll be it. I don't see why you can't do that.
Yeah, because I would think that would save so much time. Like, why go through a whole, like, almost not trial, sorry. I mean, why go through a whole arbitration hearing and have the whole sort of formality, right, all over again, and swearing, and then, the direct cross-examination, like the whole bit is so time-consuming. Okay, that's great. Are there any final comments that either of you want to share with our viewers?
I think we've covered a lot. I think the
Yeah, it was great.
viewers will have a lot to chew on.
That was a lot of information today. Marty, are you okay? Sound great.
Yeah, it's a pleasure being on here, and I thank you very much.
Well,
Yeah, it's good. I mean, I think I like the family dispute resolution process. I think it's really great after having been involved in so many years of litigation and destroying people's lives and seeing lives destroyed.
It's
Like,
crazy. Yes, I'm really happy that I have the pleasure of both of you appearing today to share your knowledge, your expertise on this method, because I think maybe a lot of people have heard of mediation and some people have heard of arbitration, but the Med-Arb hybrid, I think this is a little bit more specialized. And if your lawyer doesn't tell you these things, you don't even know, right, that you've got this option. So thank you very much today for coming in to speak to us about that. Our speakers have provided some helpful resources. So please, I will put these in the description below for the links. We hope that this video offers you some more options to consider in your situation. If you're new to this channel, don't forget to subscribe and hit the bell so that you can be notified of our upcoming videos. Thanks very much for watching, and we'll see you next time. Bye.
Thank you.
oh, mother.
Bye.